This is BizPulse, only on Africa News Network, First Fast Live. My name is Cindy Mabi. Good evening to you. The Constitutional Court has reserved judgment in the case of brokering firm Assign Services. The firm was seeking clarity on the law relating to the employment of temporary workers. Assign Services wants the court to review provisions of the Labour Relations Act. This following the Labour Appeal Court ruling that temporary workers under labour brokers must be made permanent after 3 months of employment. ANN7 reporter
Scores of members of the National Union of Metal Workers of South Africa protested outside court as arguments were being heard. The workers say what the brokering company is seeking from the court is another form of exploitation.
It was not just a victory for NUMSA members, it was a victory for all workers in this country. Yes. Comrades, you will appreciate that we took to the streets, we marched, demanding that the ANC government must ban labour brokers. We didn't mince words, we said ban. Yo, they're calling English. Ooh, That ooh, ended up with something called regulation. They said, look, they will not ban labour brokers, but they will regulate labour brokers. And this regulation meant that in terms of the new amendments, that after 3 months, big English, we are here today because of big English, instead of banning labour brokers.
The workers received support from other unions, which included the Casual Workers Advice Office and the South African Federation of Trade Unions. The workers say they came to defend their rights.
No, so labour brokers are modern-day slavers. So actually the decision by NUMSA and other forces that you see joining us today, it is very key to challenge this process. And I mean the audacity from the side of labour brokers to take it higher up to the Constitutional Court, it shows how prepared and how determined the employers are to brutalize and exploit workers consistently.
Mina kule company ngisebenza kuyo, ngisebenze for 5 years now. Manje 5 years sebenza lapho. Istate ukuthi basithathe ipermanent, abafuna ukuthatha ipermanent, change a broker, bathi bas move from one broker to another broker.
Last year, NUMSA won a case at the Labour Appeal Court confirming the rights of temporary workers. The court handed down a decision to reinforce the rights of temporary workers contracted to labour brokers. Meanwhile, workers remain hopeful that justice will be served. ANN7 Constitutional Court, Johannesburg.
And joining us in studio, Edward Mitole, political analyst, and Pagamile Hlubi Majola from NUMSA as the spokesperson on Skype. And we have Mosiri Tsiane, South African Liberty Foundation chairperson. I'll start with you, Pagamile, and congratulations. I see the double-barrel surname. I suppose the champagne, we should be clicking glasses. But good evening to you, and thanks so much for joining us. In terms of labour brokering, make us understand how this is problematic to workers.
Thank you, Cindy. I appreciate the congratulations. Indeed, as NUMSA, we are completely opposed to labour brokering, and that's why our position officially is that we would like the system to be banned outright. We say this because there is not a single worker that you will meet who has a positive experience having worked under labour brokers. Our experience with our members is that this particular type of service is a very highly exploitative service. You have a middleman who benefits from the hard work of a worker, when in fact the main employer could just employ them directly. In many cases, the majority of workers who work for labour brokers earn less than what permanent workers earn. They don't have access to benefits. They don't have access to credit facilities because their contracts are short-term. So ultimately, the lives of ordinary workers under labour brokering has been very, very bad overall, and the experiences have been extremely negative. And that's why we describe it as a form of modern-day slavery. And as NUMSA, we would like to actually see this system completely banned in South Africa.
All right, talk us through the Constitutional Court now in reviewing the Labour Relations Act to employ workers that have been with a company for over 3 months. We've seen this even in state-owned entities where we freelance. For example, I've been with the SABC, yourself as a journalist, or if you have freelance, that there is no job security, and no matter how many years that you have been there. So do you think that there needs to be a general overhaul of the Labour Relations Act with regards to casual labour? All right, we're going to have to reconnect with Phakamile in a little bit. Mr. Mitole, in your view on how this can be a win-win situation where you don't necessarily deprive an existing industry of placement agencies or labour brokers, for example, and yet also ensure that labourers are treated fairly?
Good evening, Cindy, and good evening to your viewers at home. I'll start by saying that I'm wearing this odd military fatigue as a respect to NUMSA, which is the only militant trade union in the country. While other labor unions are preoccupied with factional battles in the ANC, NUMSA appears to be the only labor union that is interested in pursuing matters to do with the exploitation of workers in this country. So big up to NUMSA. I understand that NUMSA already recorded a victory in mid-July 2017 when they approached the Labour Appeals Court, and the Labour Appeals Court made a decision to reaffirm the rights of exploited workers in this country, especially temporary workers. You must remember that the Labour Relations Act, Section 198A, subsection 3B, reaffirms that temporary workers who are placed with major employers by temporary employment services automatically will become permanent employees upon the expiration of that 3-month period. So when the 3-month period expires, temporary workers become the sole responsibility of the main employer. In this case, assigned services ceased to have responsibility over those workers after the expiration of that 3-month period, which means that the host shaving and stacking company was the sole employer. But when NUMSA approached the Labour Appeals Court and recorded that victory, Assign was not happy. So they appealed to the
to the Constitutional Court. Mr. Mitole, just stay on the line. We do have Phakamile Hlubi back on the line with us. And just in terms of what this means if the Labour Relations Act is revised, especially when it comes to temporary labour. And the second question is, do you think that the employer's attitude is that labour is a dime a dozen, easily disposable, you'll find another at any given time?
Is your question that should the decision be reviewed? Is that what your question was?
No, I'm saying what changes can be made in the Labour Relations Act to protect casual labour, because it's not only the labour brokers, but there is certain provisions thereof within the Act that says, you can be a casual worker. Should that be reviewed?
So as your expert correctly put it, the provisions that are there at the moment are the reason why we were in court to defend this case, because of the fact that we believe that the interpretation of the Labour Relations Act in its current form is the correct interpretation. Temporary work is supposed to according with the Labour Relations Act.
Yeah.
And so what we found is that, and that's why Assign felt that they needed to take this issue to constitutional court, because like many companies, they want to exploit workers. They want the benefit of being able to take the the earnings of the worker and instead of passing that on to the employer direct. The whole concept of labor brokering in South Africa should actually be completely reviewed, because it doesn't make sense that in the context of a country where we are suffering with high unemployment and joblessness, why are we not giving people opportunities to become permanent employees of the main employer? Why must you have a middleman, which is precisely what a labor brokering company is, to manage that process? All it does is it results in a situation where workers get exploited, which is what we've seen happening for the last 23 years. We heard labor brokering companies in court today trying to justify their practice, trying to pretend that, you know, there are some companies that adhere to the law. But do your research, do your own research. You will find there is not one worker who can speak about a positive experience with labor brokers. So really, it's an idea that should have been removed long time ago if this government cared at all about working class issues.
All right.
And that's why.
And I hate to break your word. Let's talk about the case in the Constitutional Court around assigned services in seeking clarity relating to the employment of temporary workers. What was the whole exercise about, if you are saying there's no ambiguity in the interpretation of the LRA?
So the issue there was the fact that they interpret the Section 198 to say that the contract worker or the worker who was employed by the labor brokering company now falls under has dual employers. So in other words, the labor brokering company and the main employer are both tasked with the responsibility of being employers in that context. That's how they've interpreted the law. We are arguing, in line with the decision which was handed down by the Labour Appeals Court last year, that there is the way this act should be interpreted is that there's a sole employer after 3 months, meaning that you've worked for a labor brokering company for 3 months, thereafter you are eligible and you become permanent, the permanent employee of the main employer, eligible for the same benefits and rights as other permanent employees.
What are the punitive measures then if, in this case, the main employer refuses to absorb that particular employee into a permanent position because of the agreements they may have with a brokering service?
Part of the problem that we've experienced with labor brokering companies is the fact that there is very little compliance with the legislation. And to make matters worse, organizations like the Department of Labor and CCA to comply. And that's precisely why, as NUMSA, we've always felt very strongly that the regulations are in and of itself are not enough. We want a total ban on labor brokers because it doesn't make sense that we have these laws, we have these regulations, but for years these companies have found loopholes in the system to allow these contracts to be extended in perpetuity. You have situations where casual workers have worked for companies for in excess of 10 years, which is really ridiculous and unfair. But this happens. And even though employers are wrong and they know they're not complying, there's nobody to stop them from doing this. The Department of Labor certainly has not acted against them or is slow to act against them. So really the only solution that there is for there to be a total ban on the system.
All right, and how far is that process, or what shape and form will it take in banning that system, Mrs. Majola?
Well, the problem with that is it would require, it's almost a constitutional issue. We're not at the point where we can say that. This is something that would require a change in the legislation. Right now, labor brokers are regulated, they're legal, they're allowed to operate. We would need the law to change for that to change. So our next step really, once we hope to be successful, obviously, with the Constitutional Court, but we want to make sure that we sensitize the working class in general in South Africa to join us in fighting and lobbying the state, putting pressure on the state to ensure that the system is in fact banned, because we know for a fact that it does not work. Workers are not happy with it, and it results in severe abuses of the Labour Relations Act.
Well, thank you very much for your time. Of course, we have on the via Skype Phakamile Hlubi Majola, NUMSA spokesperson, talking to us about the Constitutional Court with regards to assigned services. And thanks for your patience, Mr. Mitole. Essentially here, it seems like a policy issue that in the view of NUMSA that perpetuates to exploit workers. So again, what is the middle ground? What is the win-win situation?
When it comes to the affirmation of the rights of exploited workers, there is no win-win situation. You must remember that foreign direct investment, by its very nature, is exploitative. This is why I've always said that we don't need foreign direct investment in Africa. International foreign-owned capital, together with indigenous-owned capital, conspire to exploit the workers, because the whole system of capitalism is founded on the super exploitation of workers and super profits. So the only solution to the plight of exploited workers and oppressed peasants in Africa, and in South Africa in particular, is the radicalization of the masses. Change will not come via a formal policy shift alone in the ANC. Change will come by political education and radicalization of the society, which would empower the local people, the masses, the oppressed people, and the exploited workers to reclaim their dignity. You must remember that we have been jailed by a system that continues to exploit the workers. We have been jailed by a system that continues to enrich the few and exploit the majority.
So how do you counter that system? Because you could call it a cartel or, capitalism at work, in the sense that those particular networks will create subdivisions of the type of work that they do, employ maybe a friend's company to provide the labor, etc. So how do you counter that particular system so that at least the workers are given a decent wage, that their conditions, if their working conditions were different, I don't think we'd be having this court cases?
It's quite problematic because the system is quite entrenched. It is entrenched in the Constitution. It is entrenched in attendant legislation that has been passed over the years. Remember that the CODESA and the constitutional process was captured from the word go. So white monopoly capital and the imperialists who were interested in South Africa, who had vested interests in South Africa, made sure that they had their own people at the CODESA negotiations, at the constitutional processes, to ensure that the constitution was manipulated to include their demands. So the demands of the long-suffering masses of black South Africans did not find input into the constitutional processes and the CODESA negotiations. So black people were deceived at CODESA. They were duped. In this way, it is very difficult, Cindy, at the moment, to make sure that there is a win-win situation between the corporations and foreign direct investors that continue to exploit our people in South Africa and in Africa in general, and the exploited masses. So the only solution, as I've already said, lies in the ANC itself.
But these are private businesses. You know, in public institutions, you could perhaps have more influence where you can insource services. We've seen the riots around higher institutions of learning where students were saying that, you know, the external security, for example, is more problematic, and it adds to the inflated budget of the institution. So in a private business, though, you know, government can't necessarily impose to say you're not going to use labor brokers because that is legislated. And if, for whatever reason, there is a further impasse, people could lose their jobs. So there's that threat of preserving jobs while also ensuring that there is fair treatment.
That's the tragedy of foreign direct investment and creating an investor-friendly environment, because I think the government is preoccupied with creating investor-friendly environment, attracting foreign investors at the expense of the people, of the indigenous native peoples of this country. So it is going to be very difficult for the government actually to reclaim that, because it appears even multinationals, even multinationals themselves have made sure that they run away from responsibility of taking care of their employees by starting labor brokerage on the side and registering them under different names, and you know, to make sure that they escape from taking care of their workers, because they know direct employees are entitled to so many other benefits, including health insurance, including access to medical
benefits. Yeah?
Yes, exactly. So they run away from that by starting brokerage firms on the side. So you must not be deceived. Most of these private labor broking firms are actually aligned, are attached to the main employer. So they run away because they want to super exploit our people in Africa and in South Africa.
Well, wouldn't that, though, be public information? Because most of them would be listed anyway, where we can see the dual directorship and the conflict of interest, as you are saying, and how the entire hierarchy is still there to serve the monopoly and exploit workers, and that should be a case that the Constitutional Court would, I'm sure, would want to look at.
The system makes it very difficult for you to access that information, because you must remember that power in this country. Do you want
to take that? It might be urgent.
I don't think so. You must remember that the ruling class in South Africa is not the African National Congress. The ruling class is white monopoly capital, both foreign and indigenous, because they conspire to make sure that the system serves the interests of the people who have control and ownership of the means of production. So this information is not readily accessible. Even when you go to the Competition Commission, even when you go to your own government-owned institutions that are supposed to follow up and investigate these matters, you will not be able to access this information, because you must remember that white monopoly capital is corrupt in its nature. Actually, state capture and corruption is embedded in the system of monopoly capitalism. So there is no way that they would present this information to you.
Maybe not in so many words, based on our constitution and various legislation, that it's called collusion, it's called price fixing, it's called manipulation of the rand, or anti-competitive behavior. So I need for you to mind your words and not call it corruption.
I disagree. I disagree, Cindy, because it is time now that black people need to rise up as a nation and actually face this monster, this enemy head on. We cannot continue to play catch up to a system that continues to work against us, to work against the future of our own children in our own land. You must remember that black people live like foreigners in their own land. because the processes, including the sham Truth and Reconciliation Commission, which forgave white criminals and apartheid oligarchs, actually entrenched a system of apartheid and dual economy up to this day. We live in a country where the black people have their own economy and the apartheid oligarchs have their own economy, which does not make sense. I've always, to the many speeches I've given around Africa, I've always said that the solution to Africa lies in the Green Book from Muammar Gaddafi. You must remember that Libya under Muammar Gaddafi made some important interventions, made some important strides in terms of reclaiming the dignity of the people of Libya and Africa in general.
Yeah, Mr. Mitole, we're going to have to leave it there. That's Edward Mitole, political analyst. You can also join him on social media on his very detailed and very insightful analysis of Africa and how we can reclaim the dignity, self-reliance, and restore the pride of the African continent. Thanks indeed, as always. And we had on the line Mrs. Pagamile Hlubi Majola, NUMSA spokesperson. Just love having to say that, Mrs. Majola. Congratulations again if you're still watching. But we'll take a break. We'll see you shortly.